Welcome, everyone. Please excuse my Missouri allergies today. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. And folks, today starts a several-parter in regards to the Judge Rotenberg Center on Trial, Part 1. This goes back to April 16th, 2012. And it was a long trial, folks, with several intervals. So let's try to just get through these here. There we go. Now I can see y'all. Sorry about the hair. April 16th, 2012. I'm going to include the link here in the description box so you can also read it for yourselves if you would like to. By Shane Neumeyer. Almost 10 years after Andre McCollins was restrained face down for several hours and shocked 31 times over that interval while attending the Judge Rotenberg Educational Center in Canton, Massachusetts, the lawsuit against the program and some of its most important staff for the abuses, McCollins' Guardian versus Van Hayen et al. Has finally gone to trial back that week. The trial, which began that Monday with jury impanelment, is taking place at the Norfolk County Superior Court, in Dedham, Massachusetts, and it is expected to last through the next week. The suit is a negligence suit, specifically a claim for medical malpractice, which would require that the McCollins family prove that the JRC did not meet the standard of care expected within the medical community, and that its failure to do so was what caused Andre harm. Cheryl McCollins, Andre's mother and guardian, has filed the case on her son's behalf, as Andre himself has been permanently institutionalized in a state hospital since 2006. She has named as defendant not only the JRC itself, but also Dr. James Riley, the doctor who had been directly responsible for Andre's care at the facility, Dr. Robert Van Hayen, who was at the time the JRC's clinical director and now runs the program, and JRC founder Dr. Matthew Israel, who at the time of the incident was the JRC's program director. Presiding over the case is the Honorable Barbara Dorch Okara, Justice of the Superior Court. In what was perhaps a surprising turn of events, given the JRC's reputation for being highly successful in litigation, and the fact that the video footage of the incident were suppressed by court orders 8 years before, Judge Dorch Okara allowed the tapes not only to come into evidence, but to be recorded by news cameras, to be shown on television to the public, which is what I've shown you on this channel before. This was made over the objections by the counsel for the JRC and other defendants who insisted the viewers would not be able to judge the appropriateness of the shocks and restraints without having more context by which to understand their use. Whatever, Karen. According to Fox News camera crew at the courthouse, the footage was used as a part of the plaintiff's opening statement on the first day of trial, and the news report actually shown all or nearly all of what the jury saw that day. Also on the first day of trial, Cheryl McCollins testified about her son's ordeal and how she came to find out about what happened to him on October the 25th, 2002. That's 16 years ago, guys. This is when this started. According to her testimony, she did not expect nor want that her child be abused and traumatized in the way that he was that day. She is expected to return to the stand at the end of the plaintiff's case on Friday. The second day of the trial proper consisted largely, if not entirely, of testimony from the plaintiff's expert witness, a psychiatrist named Mark Whaley. Counsel of the McCollins family, Benjamin Novotny, of the law firm of Lubins and Meyer, walked Dr. Whaley through the days leading up to the incident at issue, what happened the day of, and what followed from it. Dr. Whaley testified, based on JRC records, that in the months leading up to the incident, Andre had been doing better, and in the past 6 months he had received a total of 30 shocks. However, following a visit home and then a change in classroom location the following week, Andre's mental state sharply deteriorated. Dr. Whaley stated that, in his expert opinion, on the day that he was restrained and repeatedly shocked, Andre was in a state of psychosis, which he characterized as one of the severe fear and distress, in which he could not learn or adjust his behaviors to meet the JRC staff expectations. Spare me. God, they're so full of lies. So let's just shock him. That'll fix it. Hey, how about next time when you all speak out of turn, I put you on a freaking 4-point board? Maybe that will solve your issues too. Sorry, I'm trying to read through. Sorry. During the testimony, counsel showed footage from the incident to Dr. Whaley, who had seen it before, and the jury, who had, for the most part, not. The jury witnessed approximately 10 of 31 shocks that Andre received that day, which were accompanied by him screaming in pain, yelling no repeatedly, and at one point saying sorry over and over again, all to no avail. All but one of these shocks, it was revealed, was for tensing up or screaming, anticipation of or response to shocks or restraints, while the other shock he received was for failure to remove his coat. A number of the shocks that Andre received were delivered through 3 electrodes, 2 in his legs and 1 in his torso. However, at a certain point, the JRC staff placed 2 extra electrodes on Andre, 1 on each arm. Dr. Wells' testimony established that these 2 additional electrodes were used in violation of Andre's mother's consent to his being subject to contingent electric shock, in that she had specifically requested that he not have any electrodes on his arms only shortly before the incident. When asked whether the shocks Andre received could be justified based on a theory that his tensing up could be a precursor to aggressive behavior, what the hell? Your muscles tense up in anticipation of pain. Are you kidding me? The doctor answered that, given that Andre was already restrained, they were unnecessary and unjustified, or as he put it in a remark which was stricken from the record, like something out of the 1800s. Dr. Whaley went on to discuss the consequences that Andre's ordeal resulted in. Namely, Andre entered into a catatonic state, being literally scared stiff, as witnesses described it, that lasted for 3 days, during which he continued to be restrained, though by means other than a 4-point board. During this time, the JRC did not seek outside medical attention for him, nor did it call his mother to ask her if she would like to have him taken to the emergency room. In Dr. Whaley's opinion, this constituted a gross violation of the standard of care. JRC was lucky, according to him, that Andre didn't die in their care given their actions, a statement that defense counsel objected to and that the judge ordered the jury to disregard. With regards to how Andre is now, Dr. Whaley testified that he has since been institutionalized and heavily medicated at subsequent facilities and has no prospects for independent living anywhere in the near future. The doctor attributed this serious and more or less permanent psychological deterioration to Andre's traumatic experience at the JRC in 2002. A freaking course! That's just logical. In a small amount of cross-examination, the court schedule was able to include that day counsel for defendant Dr. Riley Edward Henchy attempted to undermine Dr. Whaley's credibility. Defense counsel questioned Dr. Whaley on whether he had watched the entire approximately 7 hours worth of video footage of Andre being restrained, or merely pieces of it. While admitting that he had not, in fact, watched the entire incident, Dr. Whaley was insistent upon the fact that he did not need to in order to know that Andre had not been afforded water, bathroom breaks, or meaningful human interaction. And she also attempted to call to question psychiatrists' qualifications to comment on whether the JRC and its staff had met the standard of care, given that he is not a behavioral psychologist and has not worked in residential settings with a focus on behavioral modification. Dr. Wertley refuted this, stating he had worked in several residential facilities, including one with a focus on youth behavioral modification, and that he has made use of behavioral teachings in his own practice regularly. Finally, the attorney tried to disprove Dr. Whaley's assertion that Andre was psychotic and thus unable to learn from the aversive he was being subjected to by pointing out in the video a part in which the staff was testing out 2 extra electrodes before placing them onto his arms. Upon hearing the sound of the graduated electric decalator go off, Andre reacting with fear, and then made a remark to the staff demanding that they not give him false alarms. According to the Hinchy, this indicates that Andre had enough grasp of the situation and of the cause and effect that he could have realized that the link between his behavior and the electric shocks. Dr. Whaley denied this, however, maintaining that Andre was in enough of a psychotic state to not be able to learn or benefit from being repeatedly shocked as he was. How are you supposed to learn when you're being abused? Really? Really? For not taking off your coat. You better learn not to take off that coat. Or we're going to abuse you more. I hate these people. I hate these people. Moving on. Okay. Let me find out where I was. Cross-examination of Dr. Whaley continued on Thursday, April the 12th, and into Friday, and will be addressed in separate posts. So that's going to be coming up. So, folks, what did we learn from this little tad bit? Off the get-go, right off of the get-go, it looks like JRC is defending the shocks by using the same tropes I've heard leveled at autistics ever since. Ever since. They're out of control. They're violent. They're psychotic. They're going to cause harm. We must shock it out of them. We must shock them into compliance. Or if they don't, they'll get violent. Bitch, use those shocks on me. You find out how violent I'll get. You use them on anyone. You'll find out. Use it on some of these people who watch these videos on one of their kids. You find out how violent they'll get real quick. I am sorry, but outbursts and refusing your coat and even shows of a little bit of anger due to change in environment, which is a part of our diagnosis. We can't help it. We can learn better ways to communicate it so that we can be better assisted or find healthier ways of expressing it, but we can't help it. You can't shock it out of us. You can't shock it out of us. That's impossible. Anyways, you see where I am going with this. From their side, you have some true believers and people who just like to inflict pain. And these true believers truly do, I'll give them their due, truly do believe that what they're doing is for the best of the person who's being abused. They truly believe they have drunk the Kool-Aid. They have drunk the Kool-Aid. And when you drink the Kool-Aid, it is exceptionally difficult to then hit these folks with hard facts because they've drunk the Kool-Aid. They believe these shocks are better. They're not causing the damage that being hyped up on drugs would cause. They see basically after the shocks, what you have is, well, they're complying. Look, they're doing what they're told. Look, they're improving, not understanding that they are acting out of trauma. They're doing what they have to not get abused again. And the minute that the threat of that abuse is no longer there, because there was no meaningful ways that were used to teach better ways of being able to handle that anger, because, God forbid, common sense, these orderlies did not try and find out what was triggering these behaviors in the first place. Remember, behavior is a form of communication. If one of us is upset, whether it be a nonverbal autistic or the most regular Joe in the world, something's triggering it. Common sense would dictate, instead of throwing someone on a 4-point board and shocking them 31 times in 7 hours with no bathroom breaks and no food, the common sense approach would be find what is triggering the behavior. Fix what's triggering the behavior, and then what happens to the behavior? Right? Right? It's common sense, people. It's common sense. All right, I will be out tomorrow with part 2 of the trial and the trial coverage. Again, I am going to include the link to what I just read to you in the description box. Now, folks, as always, we here at Spilling Tea, we don't get very many views on this channel. The few views that we do get do tend to get removed by YouTube, so please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. Also, please share on all your media platforms. These students are still, after all of these years, look, this is 2012 and it's still going on. These guys are still in danger. So please share this on all your media platforms. I do appreciate your time this afternoon. And folks, I do hope you have a good one.